All righty, this We the People News. One more time at it. All right, part two. Okay. Um, there ain't no more I'm gonna say except never look straight forward. Always look around and be able to protect yourself by any means necessary. What are they doing against you? And do you really understand the laws that you read? And and have you actually looked up the definition of words they are using against you? And where did they get that authority to use anything against you? Remember, y'all, all the statutes, codes, rules, and regulations they put upon us is supposed to be married to the Constitution. It cannot contradict. It cannot contradict. And this is where we're having a hard time understanding. Well, because they brought a statute, they made us follow the statute and all that. But is that statute within the guidelines of the Constitution? Okay?
Lawful legislature or Congress, and no lawful executive. It is so bad that the entity masquerading as California is not even remotely a state admitted into the Union of States established by the U.S. Constitution. The inalienable rights of the sovereign people of California are no longer recognized and haven't been for nearly a century. I know I called this documentary Treason by Judge. There will be no shortage of evidence to substantiate those claims. But before I get into that, I want to start with the failure of checks and balances with law enforcement because of their duty to see the laws faithfully executed by all officials of government, including judges. Throughout this video, you'll hear me refer to different audio recordings and documentary exhibits. You can find all of them on my website, thespiritoflaw.com. There, you'll also find a companion document that contains a brief at law of these issues. Just click on the document image to read or download it. Underneath it is a link to the appendix, which contains the main judgments and orders made by judges and other officials for you to examine. There is also a quick link to the Audible exhibits. There you'll find the full-length versions of the edited clips I'm going to share with you in this video. Please take the time to listen to the whole version so nothing is taken out of context. Here we go.
We're going to pause right there. All right. So that being said, to all you guys out there, when you read the documents, it's no longer hearsay. You know for a fact in law that he's been going through this process. Okay? Now you're doing this pro se, himself, right? Well, he's not part of the bar member. So we're allowed to violate your rights as a pro se since you're not a bar member.
Here's Sergeant Mike Manson, the watch commander on the day I made the complaint to the City of Costa Mesa Police Department.
But don't you enforce state law and the state constitution?
Well, if you're asserting a civil rights violation, that's a federal violation. You can't just go to any local police department and file a grievance of some kind or an allegation and expect it to be investigated. That's an unreasonable request, given the scope of our authority. So the answer is no.
First of all, I made a complaint about state judges fining me almost $1 million without lawful authority. While there may also be federal claims, that doesn't absolve him of the duty to investigate and intervene, as the incidents happened in California where he had jurisdiction. An investigation is exactly what he's required to do, and there's nothing unreasonable about it. It says right here in the U.S. Constitution that no state shall pass a bill of attainder. A bill of attainder, or its lesser equivalent, a bill of pains and penalties, is the imposition of punishment, or the taking of your life, liberty, or property, without judicial process. When Manson refused to abide his sworn duties, I complained directly to the Chief of Police, Ronald Lawrence. Lawrence assigned the complaint to Internal Affairs Lieutenant Brian Watkins. Let's hear from Watkins.
It's not unlawful taking if it's done with a court order. But if the court doesn't have authority to do that,
Then the appellate court of the Supreme Court would have ruled on your behalf.
that's not what has happened. What I'm saying is that's not what's happened. And so there is a clear, egregious deprivation of rights that I can give you just undeniable evidence of that has gone on. Even though I have gone through all of those court processes, I hear you when you say that those processes should have worked and they should have done those things. But the reason I'm coming to you at this point is because those processes haven't worked at all.
Yes, we're not going to take a complaint. We're not
Okay.
going to take a criminal report on this matter.
Okay, how about a deprivation of rights report?
We are not going to take a report regarding the instances, the issues that you're bringing up.
Did you notice the first thing he said? It's not an unlawful taking if it's done with a court order. That's nonsense. Judges aren't your mommy and daddy who claim to have authority just because they said so. Their authority is limited to the scope of law, and if the law says they can't do something, that's what it means. Here it is in the U.S. Supreme Court's words. If a judge acts without authority, his judgments and orders are regarded as nullities. They are not voidable, but simply void, and form no bar to a remedy sought in opposition to them, even prior to reversal. They constitute no justification, and all persons concerned in executing such judgments or sentences are considered in law as trespassers. I also made a complaint to the FBI.
Thank you for calling the FBI. Does the FBI handle deprivation of rights by public officials? You're not being deprived of any rights, sir. Okay, I have the right to not be excessively fined. That's the 8th Amendment. Okay, I have the right to due process.
Speak to your attorney.
Sir, there are other calls that I do need to take, and as you are not reporting a federal matter that we would be able to assist you with, I'm going to go ahead and end the call. Have a good day.
To this point, the egregious dereliction of duty to investigate and intervene has been obvious by every official blatantly refusing to do one or the other or both. I could say this next situation with Sergeant Darren Joe of the Newport Beach Police Department is more egregious because of the lies he told in an attempt to convince himself, me, and his superiors that he had done his job when he really hadn't. It was like he put on a show of activities to make it look good, but when it came down to actually doing the investigation and determining whether a crime had in fact been committed, he never took the first step. During a phone conversation we had a few days ago, he ultimately told me he didn't think it was his job in law enforcement to protect my rights and property as required in this case. To his credit, though, Darren undeniably spent more time with me than any other official previously had. He didn't just blow off my complaint in the beginning like the others. In fact, over the course of about 5 weeks, we spent at least 5 hours on the phone together discussing these issues. If you'd like to hear these calls, they are exhibits E24 through E27 and the most recent E35. Darren wrote a suspicious circumstances report as part of his decision to not investigate or intervene in this case. Before reviewing it, I want to reiterate that the means of committing crimes and treason I'm alleging here isn't face masks, guns, and overt physical force like in a bank robbery. It's the manipulation of words and phrases in statutes, codes, and case law by public officials using the force of the power of the state and federal government to steal money and property without lawful authority. Robbery is robbery no matter who does it and no matter what form it takes. In this case, as government officials under color of law. In an investigation like this, where the crime is committed through manipulating words and phrases, the obvious first step is to get a firm understanding of what the words and phrases mean and the context of how they're being used. The crime scene here isn't a bank or its camera system, it's the public record, the documents in the court cases, and the precise words and phrases used by the judges in making the orders. Here's Darren's report. As far as a full, fair, and impartial investigation is concerned, we should expect to see an examination and resolution of each of the issues I reported to him were unlawful. But this resolution is nowhere to be found in the report because he never resolved them. Instead of admitting this, he lies about it, effectively claiming he did a full, fair, and impartial investigation when he didn't. The last sentence of his report reads, "This case shall be categorized as a suspicious circumstance due to the lack of probable cause to indicate a violation of the California Penal Code has occurred." End quote. In other words, he's saying that there's a lack of evidence to substantiate a crime has occurred. Of course there's a lack of evidence. He never did a full, fair, impartial, and independent investigation. He never resolved the meaning of the words and phrases that were being manipulated. What he's doing is like a cop that while a bank robbery is occurring, turns around and looks the other way and says, "Nothing to see here, folks." no evidence a crime's being committed. Let me show you what I mean. In this case, the word disgorgement was one of the words I alleged was being manipulated. The judge used this term in his minute order. If in fact disgorgement is what the judge ordered, then we need to know the precise meaning of this word to see how he had authority to order me to pay nearly $1 million for allegedly not having a professional license. As you'll hear me say over and over again, whenever a public official takes any action, they have to have authority traceable to a constitution. And they have to give that authority to you if you ask for it. If they don't have authority, any action they take is not only void, it's likely also criminal. Here's the definition of disgorgement from Webster's Dictionary of 1828, which I've heard was adopted by the U.S. Congress as the official definition of words and phrases used in the U.S. Constitution. At that time, to disgorge meant to, quote, eject or discharge from the stomach, throat, or mouth, to vomit, end quote. Notice it says nothing about a type of penalty, fine, forfeiture, restitution, or any other known remedy at law or equity to be paid for committing the public offense of not having a professional license. Let's look at the statute involved, Business and Professions Code 7031B, to see if...
Alrighty, so for some reason or other, my video froze, and we'll start on the next one. Till next time, bye y'all.